Welcome to the Curious Lawyer series. I'm Peter Afrasiabi, and I'm excited to bring you these fun, whimsical, light CLEs that are a walk through different areas that may be unknown, but of interest to you. So much CLE is often heavy lifting, it's complex, it can be in a complicated area of law or maybe a very technical area of law that you're doing for your particular practice area. And sometimes you just want something that's whimsical, light, that's fun, much like you may read a mystery novel or a romance novel just to get a break from the heavy reading, or you may watch just a light comedy to get a break from complex documentaries and the like. So are these CLEs. These are designed for the curious lawyer. So it's a walk down a different path, something that you may not be used to, but it's a fun and interesting way to learn about a different area of law and a set of issues that you perhaps never knew about. But it's important and fascinating to learn about how the law touches on so many different aspects of our modern world. And so today's topic, space, the final frontier, and this is a voyage for you, the inquisitive lawyer. Today we're going to talk about commercial space travel, asteroid mining. Yes, you heard that right, asteroid mining. There are actually businesses that are getting ready to mine asteroids. Blows your mind. Moon ownership, space burials, yes, space burials, and even extraterrestrials too. And in the middle of all this, as we learn a lot about space law and we walk through space law in the 21st century, we'll even have some doses of Star Wars, Star Trek, and the movie The Martian with Matt Damon. So buckle up and let's get going. Our first slide, space, the final frontier. Let's start by talking about what is space law. And the term space law really refers to a body of international and national laws and customs that govern all human activity in outer space. And it's of particular importance really to start thinking about this for you, the lawyer, for us as the legal community now in the 21st century, because we are in the midst of an inflection point and a real shift in terms of space and who accesses space and who will be accessing space. For the last 50 years of the 20th century, space was an area that was explored exclusively by governments, and it was a governmental endeavor that was obviously incredibly expensive, a product of the Cold War initially, and it was something conducted really only by the government. And so because of that, there was minimal need for lawyers to be involved or aware of space law and any principles of space law. But as we now stand in the second decade of the 21st century, we really have shifted with the winding down of the space shuttle program and the sort of slow demise to some extent of government expenditures in space exploration and travel. There has been a staggering increase in private enterprise and private resources devoted to accessing space, from commercial space travel to asteroid mining and the like. And all of this is afoot rapidly and now. And so space law really is something that is built on this historical legacy coming out of international treaties and national laws designed for government, which now must be forced to start adapting to this development of private enterprise. And so this is really why space law matters, because we are in the beginnings of this shift from government to private marketplace mechanisms to deal with the exploration and commercialization and the opening up of space to the public, not just to, government astronauts. And this then rolls down to lawyers in the sense that as private enterprise starts deciding to look for ways to monetize and create business models around taking people into space or mining asteroids, questions then arise about liability, exposure, contracts, what jurisdictions law applies, and the like, as well as capital wants to invest in these things. And so legal regimes have to be developed and have been developed, as you will see in this program, and are being developed and will need to be developed further to really get our arms around space law and what it means. So the legal topics that space law touches on, as you see here, are international laws, and these are the treaties that govern in this area. And then we have specific property right regimes we'll talk about, and these relate to ownership of the moon, to celestial bodies ownership, and to asteroid ownership and mining. And this gets to actual space mining. And then we have to also look at tort regimes, and this sort of deals with tort liability for what happens when there's damage occasioned by one person's space vehicle or space object to another person's space vehicle or object, or upon re-entry to something on Earth. And then we have, because we are now in the beginnings of commercial space travel and space adventure for private citizens, we have to have developed and have existing developing regimes dealing with tort, negligence, liability law for commercial space travel standards in these liability regimes. So let's start in the beginning, the Outer Space Treaty. And this kind of gets to our first question: who owns the moon? The Outer Space Treaty really is the most fundamental piece of law. I mean, it is the most fundamental piece of law regulating space, and it's controlled really all subsequent space law developments since it was enacted in 1967. The formal name of this treaty is the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. The preamble to this treaty refers to, quote, the common interest of all mankind in the progress of the exploration and use of outer space for peaceful purposes, and that, quote, the exploration and use of outer space should be carried on for the benefit of all peoples, irrespective of the degree of their economic or scientific development, end quote. Those are sort of the root pillars that underlie the space treaty, this idea that it's part of the common heritage of humankind to move into space and explore it, to learn new things from space, but it benefits all peoples. It's not just for those who are first there. There's this sort of anti-discrimination principle that underlies that, obviously, in terms of it not being the property of those with superior economic power. And as of 2017, there are 105 nations that have signed this treaty, including, of course, the United States and European nations and Russia. And this fundamental treaty is what really governs everything. And so on the next slide, you can see the four basic pillars from this treaty. The first one, coming from Article 1 of the treaty, deals with property and ownership structure issues. And what it posits and provides is that all may explore the moon and all may explore any celestial body freely for peaceful purposes. You can think of this as space fair use, so to speak, if we were to riff on intellectual property, copyright principles from the terrestrial world of fair use. Here we have space fair use. The other pillar to this property ownership structure idea is that no state may own the moon or celestial bodies, and no state may put military bases there. And this is in effect what's known as the space non-ownership principle. Now, what's important here is that although the treaty provides that there can be no military bases on the moon or celestial objects, it doesn't have a prohibition on orbit-based weapons. So non-weapons of mass destruction are not prohibited, at least from being orbit-based, as opposed to nuclear bombs, for example, which are prohibited. Now, the other principle here is that any state that launches any space object must retain full control jurisdiction over that object. So, if the United States space shuttle goes up and is orbiting around, the Earth or the moon, wherever it may be in space, it is United States soil, so to speak, and United States jurisdiction. The second pillar to the international treaty is that there's a safety structure that it incorporated. And that is that there can be no space or Earth orbit weapons of mass destruction, period. In other words, it may be that you may have a missile that gets launched or some Star Wars space defense system from the 1980s we know about, but there can't be actual nuclear weapons and other weapons of mass destruction that are placed into Earth orbit or on the moon, for example, by any nation. The other part of the safety structure here is that everyone has agreed through this treaty that they will not contaminate space or create adverse Earth effects. And that principle is a very important one, which as you fast forward from 1967, 50 years to 2017, where we are now, the concept of what it means to contaminate space or create potential Earth adverse effects is taking on new life through the commercial endeavors that are occurring and requires evaluation and understanding of what this language means and the scope of this language. The third treaty pillar that's important is that there's a liability regime. Any state that's launching a satellite or a rocket into space is liable for any damage caused by that to any other state injured by the launched object. And this is just a basic negligence principle from our common law regimes that's been adopted into this international treaty that the United States has adopted and ratified. And then the fundamental fourth principle is that there's really a freedom of scientific investigation and cooperation is the key. And the core pillar, as you saw in those statements on the prior slides, is that this is about an area of common heritage of humankind, designed to have scientific investigation and cooperation to really better all humankind. And it's sort of this wonderful animating principle here. So as we go to the next slide, we can look at a fun little side question here about selling the moon. The treaty said no states can own the moon. But many of you may have heard of this business out there where people are selling the moon. And here's a copy of a lunar deed. And really, it's a fascinating little story. But since the early 1980s, there's a guy who's built a business around selling land on the moon. And he's sold over 611 million acres of land on the moon, lunar acres. And these have been individual 1-acre lots that you can buy for $19.95, and after you pay the quote-unquote lunar tax, it's $36.50 for shipping and handling and lunar taxes of your deed, and you get 1 acre on the moon. And apparently a country-sized plot of land has been sold on the moon, 2.66 million acres of the moon. Someone paid 250 grand apparently for that to get this lunar deed. Apparently, of great fascination and whimsical fun here, Presidents George H.W. Bush, Jimmy Carter, and Ronald Reagan even owned plots of the land on the moon too. Pluto's for sale for $250,000. So the question is, can you sell the moon? And can you actually get any title to the moon if you pay this $19.95 for your acre? And the answer is no, not really. The Space Treaty prohibits national ownership of the moon, and the United States ratified that treaty. And so that treaty as a federal enactment really would preclude and preempt any purported state-based private ownership over the moon. As to sort of why and how one could own it and not someone else, it just sort of would have to preempt it. And so the treaty may well talk about national ownership, but it also makes clear in the treaty that non-governmental actors in space are subject to the same standards through the national enactment of the treaty under domestic law. And so if the U.S. can't own the moon, and its citizens really can't either, and that's the best read of the treaty. But if you want a lunar deed, it's $19.95, and it's kind of fun. The next slide we get to is we're going to talk a little bit about the liability structure here in space law under the treaty. And there have been subsequent conventions adopted by the U.S. and other countries that expand upon really liability and liability standards and how they work in space. And so, in essence, there's general strict and negligence liability rules. And they roughly follow as follows. There is strict liability for any injury occasioned on Earth due to space mistakes. And so, if you have a satellite that falls out of orbit and comes back to Earth and blows up someone's car, there's strict liability that attaches to that, even if you didn't do anything particularly wrong in causing the satellite to re-enter. Now, if the damage occurs outside Earth, such as up in space orbiting around the Earth or floating around the moon or wherever they may be one day in space, under the current law, it's assessed based on whether that damage occurred to one vehicle by another if the injuring party is at fault. So I suppose if one flew their spaceship into someone else negligently, they would be at fault. If you think about this, though, it creates massive practical factual proof problems where there are thousands of objects orbiting the Earth right now. And if one object crashes into another object and damages it, how anyone could figure out even what object necessarily hit it, let alone who was at fault, what happened, and how it happened. Immensely complicated factual proof problems in there that will have to be sorted out by future generations of space lawyers as they deal with these claims. Now, there's a fascinating 1979 Moon Agreement that really was an attempt to bring much more clarity to the property rights in the moon and celestial objects. What's critical here is almost no nation has adopted it, and critically, the United States never adopted it, neither did Russia. The EU nations and China have not adopted the Moon Agreement. And the Moon Agreement's important in the sense that it really sought to put limits on what people could do when it comes to commercial exploitation, harvesting of assets off of celestial bodies. And so the Moon Agreement provides neither the surface nor the subsurface of the moon, nor any part thereof, or natural resources in place, shall become the property of any state, international, intergovernmental, or non-governmental, national organization or non-governmental entity, or of any natural person. So you can't own, no person can own any part of the moon, period, end of story. States have the right to explore and use the moon without discrimination of any kind on the basis of equality in accordance with international law and the terms of this agreement. So this sort of fantastic concept of the moon will ultimately be owned by no one and it's free to be studied for scientific purposes for all has not been ratified by all nations, and so it's not controlling law. And so the result of this is that while personal ownership under the Master Treaty are not okay, mining hasn't been addressed, and so the idea of whether companies can mine the moon or other celestial objects remains an open one that we'll talk about soon. So, as we're talking about the space treaty, let's take a look at this clip. And this is a fantastic clip. It's the first one we'll watch. You've probably seen the Martian movie starring Matt Damon, and it's an incredible movie and a fantastic book. And let's watch this clip and then we'll chat about the question the clip raises, which is, was he a pirate or was his behavior lawful?
I've been thinking about laws on Mars. There's an international treaty saying no country can lay claim to anything that's not on Earth. And by another treaty, if you're not in any country's territory, maritime law applies. So Mars is international waters. Now, NASA is an American non-military organization. It owns the HAB. But the second I walk outside, I'm in international waters. So here's the cool part. I'm about to leave for the Schiaparelli crater where I'm going to commandeer the Ares 4 lander. Nobody explicitly gave me permission to do this, and they can't until I'm on board the Ares 4. So that means I'm going to be taking a craft over in international waters without permission, which by definition makes me a pirate. Mark Watney, space pirate.
All right, so you saw that wonderful clip about Matt Damon thinking about the laws on Mars and the international treaties. And so let's work through his hypothetical, because it really actually is a fascinating hypothetical to put together the pieces of the international treaties and the laws to figure out whether he was right. And so it's not actually correct that the law of sea applies. The space treaty is actually built on the same principle as international waters, but the treaty, the space treaty, actually controls Mars, not the law of international waters, which only apply to terrestrial earthbound waters. But nonetheless, it's absolutely correct that United States jurisdiction existed on the HAB, and it also existed on the Ares 4 lander. So technically, Matt Damon was not a pirate when he took the Ares 4 because he was an American astronaut on an American ship. Now, he may well have been in breach of his employment, though, but he may have had a necessity defense given his dire situation. But here's a fascinating question. What if it was a Russian astronaut? A Russian astronaut would be a space pirate under that hypothetical. So Mark Watney, not really a space pirate, but perhaps a space thief of the Ares 4, and he may have a problem with his employer when he gets home. Let's now look at the next hypothetical, and this is the legal hypothetical 2 we're going to look at, and this is a question of space burials. Not an issue you would think really mattered a whole lot, but it was addressed in the international treaty about the contamination of space and what should happen. And here we'll watch a clip from Star Trek 3, the original Star Trek movies from the 1980s. And here's a short little clip dealing with the burial of Spock in space.
We are assembled here today to pay final respects to our honored dead. And yet it should be noted that in the midst of our sorrow, this death takes place in the shadow of new life, the sunrise of a new world, a world that our beloved comrade gave his life to protect and nourish. He did not feel this sacrifice a vain or empty one. And we will not debate his profound wisdom at these proceedings. Of my friend, I can only say this. Of all the souls I have encountered in my travels, his was the most human. Others? Huh?
All right, so you saw that fantastic service they had for Spock, and Spock was buried in space. And the question we have to confront on the next slide is this a go or no go? Well, sending a dead human to decompose in space, even though Spock may not have been human or half human, but we'll put that aside. Sending a dead human into space to decompose is actually a contaminant under the Space Treaty. And so the short answer is there can be no Spock burials in space. Now, this is actually, in the real world, this is actually something that NASA is now dealing with because of the length of time and the number of trips to the International Space Station and the amount of people who will be going up into space in the very short and medium and long-term future. They're trying to figure out mechanisms to deal with this to avoid creating contaminants in space and violating the space treaty. And so one fascinating solution that has been assessed by NASA and is on the table for collaboration between NASA and a private party is to create what effect is an airtight body bag where the dead body would be placed. It would be placed then in space, being exposed obviously to the absolute freezing temperatures of space. And in effect, the equivalent would be that the body after about an hour would be brought back in, and it's equivalent to sort of being placed in liquid nitrogen, at which point once the body is brought back into the airlock in the spaceship, it would be vibrated at a high speed and the body would literally explode into powder. And so you would now have this deceased astronaut or person who's been reduced to a pile of literally powder. It's a fine powder dust, apparently. That would then be stored on the craft for delivery back to Earth for proper disposal so that space is not contaminated. And that, believe it or not, is a real issue being decided by NASA currently for how to manage the law of contaminating space. Let's turn to our next topic now, which is the International Space Station. The International Space Station program is governed by a variety of legal agreements between subset signatories to the Space Treaty. And it's a cooperative program between multiple nations, and it has its own governing agreement that governs how the space station is used, how it, what may be done there, what may not be done there, who's responsible for what happens there, and those types of legal questions. And this agreement is the International Space Station Intergovernmental Agreement of 1998. And the legal framework of this agreement is as follows. Each space station partner extends its jurisdiction to outer space on its elements on the vessel under this rule of law. And the quote is as follows. Each partner shall retain jurisdiction and control over the elements it registers and over personnel in or on the space station who are its nationals. That comes from Article 5. Now the result's really interesting here because what the result means is that each state's law, each nation's law that is, applies to its constituent components. So, if you think about this, if you're on the European Columbus lab portion of the space station, then the intellectual property laws of Europe and the negligence laws of Europe and what other laws could be at issue for what happens on that Columbus lab would apply to any new developments and finds. And so it's really kind of a fascinating situation. You could have some massive new intellectual property breakthrough, for example, because of some space study being done in zero gravity or whatnot. Something amazing could occur, and if it occurred on the European lab, it would be subject to European intellectual property legal regimes. But if it occurred on the American lab, it would be subject to American principles. And if it occurred on the Chinese lab, it would be subject to Chinese principles, which means any development that may happen there tracks the law of the state where the development occurred, and it becomes much like then terrestrial bound developments occurring within domestic nation states. What's particularly interesting here is that depending upon what the legal issues are, at least for the United States, where we have this dual federal state regime, it really could create complicated problems, because if you're talking about general negligence common law, and it being a negligence type situation occurring on the American lab, when you come down, there really isn't a body of developed federal negligence common law for just general interactions and behavior. And so the question may then devolve to looking to a particular state's common law and figuring out where are the astronauts, what states are they from, where did this spaceship launch from, and questions like that. These types of issues get sorted out. And part of the agreement is that if they are to be sorted out and there's to be a legal battle over this, it must occur in an international arbitration, and that international arbitration is a terrestrial one. It doesn't occur in space, of course. And so here's a hypothetical we can think about. Imagine you're on the European Columbus lab on the International Space Station, and while on that European Columbus lab that's owned and managed by the Europeans, an American astronaut comes in and a Russian astronaut comes in, and they're working on the lab and they have a fight. And maybe the American astronaut murders the Russian astronaut in a fit of anger on the International Space Station. What law applies to the murder charge? Well, under this international agreement between the parties, it would not be American law and it would not be Russian law. The law of Europe would control, and so the American would be then, upon returning to Earth, would be tried in the appropriate European court for murder of the Russian astronaut. Fascinating sort of extension of our domestic principles, domestic legal principles up into space. Now, the International Space Station brings us to our next topic, which is commercial space travel. And really, commercial space travel picks up the baton from international space travel, the International Space Station, which has been historically, obviously, a governmental enterprise for scientific and explorative endeavors in space. But now we are moving into this new zone of commercial space travel, which is for private, not just governmental objectives, but also for private objectives and enterprise, just for the experiential fun of going to space. Now, if we look at commercial space travel, there are multiple massively well-funded companies that are really in a race in this space for providing, access to space and different aspects of it. We have Richard Branson's Virgin Galactic, of course, that everyone's probably heard about. We have Jeff Bezos from Amazon. He has his Blue Origin space venture at work. Elon Musk, the famous Tesla inventor, obviously, has his SpaceX program. There's a company called Moon Express, which is working towards commercial moon trips. And all of this then funnels down to legal issues for lawyers. And the various legal issues that we need to look at and think about involve things such as qualification metrics for provider safety. And this is both for the safety of passengers, but the safety of the employee flight crews of these companies that are providing these services to people. There are massive issues, legal issues, about providing requisite informed consents and what does it mean to give informed consent. What type of consent must be given the nature of this, obviously incredibly, new and dangerous and risky and exciting venture. And then there's the scope of liability and liability provisions from various regimes, both federal and state law, start touching upon this in terms of liability to space providers if something goes wrong, to component manufacturers downstream who may be making various components of the spaceships, and what's the scope of their liability if something goes awry one day. And then, of course, insurance requirements and the significant insurance-related issues that are out there with insurance companies underwriting policies to, underwrite in effect these future mechanisms and endeavors. And we're going to look at all of these now. So let's get into this by talking on our next slide, slide number 19 here. We are looking at, there is actually a federal agency that regulates commercial space travel, believe it or not. It's the FAA-AST. It's part of the Federal Aviation Administration, but there's a subdivision for commercial space transport. And this literally regulates and oversees all commercial space launch activities. And so a new acronym exists for all of you, and now that you know space law, it's FAA-AST. And the FAA-AST regulations here cover sort of 5 general issues, and that is the application process for private commercial spaceflight, various launch licensing protocols, including what are the launch pad operations and protocols that must be employed to lawfully and legally launch into space, safety protocols that go along with launch, and then you have safety and other space flight requirements once the spacecraft is airborne and in space, and the necessary systems, and then of course financial liability issues. So let's look at the first one, and that is the slide of provider qualification rules. The first point here is that there are massive federal regulations that exist in terms of the nature and the quantum and the kind of crew qualifications that a crew must have in order to be a space crew. Much like we have crew qualifications for flying a Boeing aircraft as we get flown around the country and the world, there are similar qualifications for crews who will be flying in space. Spaceflight obviously being more taxing on the body at higher speeds and raising additional issues in terms of what one is being exposed to as they fly at such speeds and in zero gravity and the like. There are significant federal regulations in these FAA provisions, and these are all in, as you see at the bottom of the slide, in the Code of Federal Regulations. But there are regulations on the training of safety for the flight crew, including abort protocols where aborts must occur for safety reasons, and then how to manage emergency scenarios in the event of, massive emergency problems. Think Apollo 13 and, now being applied to commercial space travel. What do you do? And all of this has been, not thought through entirely, but standards and protocols have actually been put into place in the Code of Federal Regulations to start creating a framework to create an environment such that as private enterprise develops these areas, the private visitors who go are within a legal regime that has at least thought through their best protection. Some of those provisions include the demand that, as you see on number 2 here, that crews must be able to withstand certain stresses of acceleration, deceleration, and then microgravity issues in these extreme conditions. And that means not every pilot can do this. It's a subset of pilots who are going to have the skills and ability to do this. The next issue is that there is actual FAA federal medical licensing requirements too, in terms of health, medical and psychological of the pilots and ultimately crews in these situations, because it'll be crew-based as well as just pilot-based. The fourth provision here is that there are in fact security provisions in place to preclude participants, you and I who may go up there one day, from endangering the flights. In other words, you can think there's a space TSA framework being put into place to deal with making sure that those who get on a spaceship don't risk blowing it up or causing damage. And some of the additional nuanced provisions in these federal rules that are really focusing at making space travel as safe as possible by our regulatory regimes include redundant life support systems for a multitude of different scenarios. Atmosphere must have redundant life support systems, proper pressure monitoring must, analysis of contaminants and the ability to preclude contaminants must, and redundant ventilation systems too. It's really a fascinating set of CFR provisions that those 5 distill from, and if you want to look at them, you can go find them at 14 Code of Federal Regulations in a variety of subsections. It would be 460.4, 460.11, and 460.53 deal with those provider qualification rules. The next topic is notice requirements and waivers. And here there are specific federally mandated notice requirements to participants. These cover things such as a risk of launch and reentry. And these are actual, if you go read, it's remarkable, but this is the federal statements of law as they currently stand in terms of what you're supposed to do in terms of giving notice about the risk of launch, risk of reentry, the absolute risk of death and injury, including complete, total, or partial mental or physical disability as a result of going into space, and then the existence of myriad simply unknown and unpredictable hazards. The provider is also required to provide to all participants an exact safety record. This is something far more detailed than anything that is mandated in any other scenario. The exact number of flights that have been taken, the exact number of people, the exact number of launches and reentry. Really, it's sort of the ultimate in terms of space due diligence, in terms of getting into the bottom of everything that has happened with this flight in space and how many times this provider has done it. There's also a requirement that there must be an in-person oral question and answer session given to all participants. So, you can't just have people write a check, show up, and then get on the plane. There actually has to be this physical sit down where there's a description of the risks and the issues and the problems that could occur, and people are given this question and answer session chance. And this is all aimed at making sure there is as much informed consent as humanly possible, so that if something does go wrong, liability is as limited as possible for the providers. And there's a federal mandated requirement that there must be a signed written consent. And particularly fascinating, when participants provide a signed written consent of their awareness and their exposure to all the risks and whatnot, they also must provide an absolute waiver of all claims, to the extent they may have any, that could be brought against the United States of America for the provision and facilitation of any travel in space. And so this becomes, in essence, entirely a private enterprise, private claim-based system. So if a Virgin Galactic spaceship takes off and blows up, claimants' claims, if any, are going to be down to Virgin, the insurer, components, parts manufacturers, to the extent there's claims there, that kind of a regime. And this is found at 14 Code of Federal Regulation 460.45 and 460.49. The next topic governed by the federal regs here involve financial responsibility rules. And here you have a very detailed schemology that has been adopted by the Space Travel Division of the FAA and the United States government to regulate the financial responsibility and what's required of space providers on the finance side in order to make sure people are as protected as possible. And so these are specifically federally mandated liability insurance requirements with additional insureds being third parties, participants, and even government personnel. And so those are just simply federally mandated insurance policies that Virgin Galactic and SpaceX and the like must have. Now, the FAA has calculated maximum probable loss, and so requires that there be up to 500 million of required coverage for liability insurance and 100 million for property damage. And so those are sort of current maximum probable loss values that the FAA has ascribed and has required insurance. And you can imagine how expensive that insurance is. What's interesting here is that this is not an area subject to exclusive federal jurisdiction in terms of legislation. Congress has not passed any laws that have preempted state liability, state insurance, state negligence laws here, such that the federal government can exclusively legislate in this area. And so because there's no exclusive federal preemption and the federal government hasn't taken over this area, it is actually subject to dual regimes and dual potential regimes in terms of federal and state liability structures. So if we turn to the next slide, what's particularly interesting is that there are certain state liability structures where states have passed laws more beneficial to space providers. and laws that are more beneficial to other participants in the space industry. And some of these states are Florida, New Mexico, Virginia, and Texas. And the reality here is that these laws are looking to maintain dominance, and these states are looking to maintain dominance over the space industry through these laws by creating legal regimes that protect the space providers as much as possible, and thereby enable the space providers to stay rooted in those states and bring the business and all the the accompanying business that occurs to those states and those local economies. One fascinating law to look at is New Mexico's Virgin Galactic Law. And this is a law that ultimately protects spacecraft operators from certain scopes of liability, and it protects downstream part suppliers. And so it comes out of the following situation. You have Virgin Galactic, of course, that plans to start flying tourists up into outer space, and it's going to be $200,000 a ticket, at least. I mean, that's currently. But you can pay $200,000 and you can fly. And if you're going to fly on a Virgin Galactic spaceship, you will leave from the Virgin Galactic Spaceport. And Spaceport America is located near the community of Truth or Consequences in New Mexico. And the existing law that was on the books in New Mexico up until relatively recently was a law that exempted Virgin Galactic from being sued for damages by passengers. So if there was an accident and the passengers had been informed of the risks, there was simply no claim back against Virgin Galactic. In other words, you absolutely assume all risk of anything that happens there. And that liability protection is really, really broad and was really critical, Virgin Galactic argued, in order to have Virgin Galactic be willing to enter this highly risky area and start providing this sort of new service in this new space world we're in. Now, that law did not protect downstream parts suppliers. And so the suppliers of various parts of the spaceship and the manufacturers of those spacecraft parts and components reached the point that they said, we can't manufacture screws and bolts and O-rings and whatever all these things are in spaceships, right? When if one of them breaks or snaps and a spaceship explodes, it's a terminal event for our company then, obviously. And so they pushed, with Virgin's help, to have the laws amended. And New Mexico actually did adopt, and the New Mexico governor, Susana Martinez, signed into law legislation that ultimately was designed to save this $250 million spaceport that Virgin is building and keep Virgin Galactic as the anchor tenant of the space industry in New Mexico. The law was passed, and so there's massive limitations of liability in terms of the ability to sue any Virgin Galactic or any downstream component parts manufacturers in New Mexico if anything goes wrong in space travel. These state liability structures are really, really important. I mean, as a traveler, if you happen to be a lawyer traveler one day, it's important to know the limited scope of liability and claims you can bring that are being designed to invest the development of this business and then the concomitant risks you bear. But if you're a lawyer who's representing, for example, some parts component manufacturer that's making parts that may downstream make their way into these spaceships, you need to be very, very well aware of what exempting laws may apply, what laws may not apply to your clients, and your clients may want to consider relocating to states that are safer for that kind of a business and making sure they have appropriate insurance to satisfy the federal government. There are also, as you see on this next slide, participant training rules. And these are federal rules that are really built around the idea that people can't just write a check and get on a spaceship and go up into space. There has to be some sort of mandatory training for participants on how to deal with some basic scenarios when they're up there in space, including emergency type situations, emergency evacuations in the water, how to manage pressure loss. I mean, a whole variety of situations like that, which obviously are required for crews, but they're also part of the mandatory training for participants, so that participants understand that they are involved in a highly risky endeavor, and they're also well aware of what, if anything, they can do if catastrophe strikes. And those really fascinating training rules, if you want more detail on them, you can go to 14 Code of Federal Regulation 460.51. Now, space travel is only, in commercial space travel, is only really one part of this new developing body of space law in the 21st century. The other component of this rapidly developing area of law is asteroid mining. And it's a true thing. There is in existence a variety of sort of different businesses built around starting to raise capital and prepare to engage in asteroid mining. And so what we really have is, to some extent, as we start getting into asteroid mining here, a situation of sort of history repeating itself simply in a new environment. Historically, prospectors have chased natural resources in all new areas. There's been gold rushes in the New World and in California. Uranium, ores, platinums, all sorts of metals and matter have been mined, and these natural resources have been sought by prospectors and companies and nations and people throughout history. And when you think about it, it includes the ocean in terms of harvesting fish for fishing. And we now have asteroids. And asteroids, as it turns out, contain water and they contain metals. And it is potentially easier and cheaper to land on an asteroid than the moon. And many of these asteroids, you don't want to think, just small little rocks. They are the size of small cities sometimes. And they contain water and metals, and science has borne out that they actually could land on them. So as we turn to the next slide, the first question we're going to ask, asteroid mining. Is this fanciful or is it lawful, and is it real? Well, there's an incredible story to be aware of to understand the history of asteroid mining. And really it's one of the most incredible accomplishments ever. And you had this European space ship, the Rosetta spacecraft, that was launched in 2004. And it traveled 4 billion miles, and literally that's billion with a B. That's not a typo on the slide. After traveling 4 billion miles, throughout the solar system, it launched a probe, and that probe left the spacecraft, and the probe actually landed on a comet, successfully landed on a comet. Now, what that probe did was then drill into the comet to collect samples. It took a variety of photographs and other readings and conducted a swath of experiments, all of which then created literally never before seen data that has, at least for that scientific study, apparently has the potential to shed light on the origins of the universe. And so what this landing was massively important in terms of the development of this new industry of asteroid mining, because it was symbolically important to prove that this can be done, but it also demonstrated that human beings actually have the capacity to land objects on comets or asteroids, which are comets of cousins in space language, and really do some amazing work on them. And in terms of asteroid mining, there are sort of 3 basic types of asteroids. You have rare M-class asteroids, which have 10 times as much metal as other asteroids. There are the S-type stony asteroids, and then C-type asteroids, which have massive amounts of hydrated clay minerals. And some platinum-rich asteroids that may only be 500 meters across, scientific estimates are that they may have more platinum than the entire reserves of platinum on the planet Earth. So, the other component here, which makes this not just science fiction but science fact, is that asteroids have very, very low gravity. And so the fuel that's required for landing and exiting on them is diminished, which makes the capacity for spaceships to land and then leave them more palatable and potential. And then here's the critical thing, why asteroid mining is becoming a real business and becoming a real set of laws, is that asteroids have an abundant amount of water on them. And water can be then extracted from the asteroids and can be used to create rocket fuel, hydrogen rocket fuel, which means asteroids can be the source of a supply of fuel for deep space travel. So rather than have to somehow get vast amounts of fuel into a spaceship out of orbit and then going through the solar system, a spaceship could potentially have gas stations, so to speak, along the way by refueling from probes converting water into with other matter into rocket fuel to facilitate deep space travel. And so all of this has literally created now a real industry. And so there are now multiple asteroid mining companies that exist. And these aren't just sort of crazy, far-fetched businesses. One of them is called Planetary Resources, and it's funded by Virgin Galactic's Richard Branson and also funded by Google. There's also a company called Deep Space Industries. And so they have legitimate business models that are built around getting probes to asteroids in order to get the water from the asteroids to convert it to rocket fuel to facilitate deep space travel. So these companies and that component of their business would be complementary to space travel companies to enable deeper travel. And then those are what we'd call off-Earth resources. And then there's also asteroid mining to get valuable metals from those asteroids, which obviously could be then returned to Earth and have great financial reward. I mean, and that's quite literally the equivalent of gold rush prospectors in the 1800s going out to California looking for gold to strike it rich. We have now new businesses going out to find platinum and other rare metals on asteroids to strike it rich back here on Earth. So as we turn to the next slide, this means we have to look at our legal regime. And if we go through our principles here, we can figure out how asteroid mining works and whether it is legal. The first place to start is the Space Treaty. The Space Treaty is the grandfather, of course, of all space law. And the Space Treaty, as you recall from the early slides in this presentation, prohibits state use or state occupation of the moon and celestial bodies. But it's silent on commercial harvesting or mining. It just talks about ownership. So, one of the first questions that has to be addressed as one looks at this is, what is an asteroid? I mean, is it a celestial body subject to the treaty? Or is a celestial body the moon and planets, much larger bodies and objects like that? Probably the better reading of the Space Treaty is that celestial bodies don't include traveling asteroids, but it's unclear. So, if the use and occupation of a celestial body were to also apply to an asteroid, then problems could potentially lurk if harvesting would count as occupying and using the asteroid. It could arguably run afoul. There's also a company called Moon Express Incorporated, which is a moon mining business. And so this company wants to get in the business of actually mining the moon. And then this gets down to the question of the moon obviously is included within the Space Treaty, but the Space Treaty prohibits use and occupation of it by one party to the exclusion of another. It doesn't say you can't dig up rocks and other things you may find and bring them home. So Moon Express probably will be okay in terms of being a moon mining business in terms of the Space Treaty. Now, asteroid mining is moving ahead a lot faster than moon mining, and so given the legal confusion, this potential uncertainty that exists for private enterprise moving in here, these companies have gone to both the executive and Congress to get help. And initially, there's been an agency response from the federal government, and this again is from our Federal Aviation Administration Office of Commercial Space Transportation, and it's responded to a variety of private companies' requests who wanted them to assess if payload reviews for extracted objects from the moon and asteroids and the legality and lawfulness of it. And the agency did look at this. The parties also went to Congress and decided they needed to get clarity here. And ultimately, a law has been passed and enacted. And so here's the law. This was ultimately signed by President Obama in 2015, and we can refer to it as the Asteroid Miners Property Rights Law. Its formal name is the U.S. Commercial Space Launch Competitiveness Act of 2015, aka the Asteroid Act. And as you see by the title, it's built around the underlying premise that we are now in a new era. We're in a new era of space exploration. We're at an inflection point of private enterprise coming here, and it will be private enterprise not just from the United States, but from other nations. And so there will now be massive competitiveness battles between nations for these potentially valuable minerals. And the United States obviously wants to get in on it and protect our businesses so they have a fair shake out there. And so the entire statute itself is built around the concept of needing to make sure that we have a competitive advantage as our companies and our businesses work here. So the expressed goal of the program is to expand opportunities and protections for private space companies looking to explore space. And the key provisions as it relates to asteroids are that private citizens, and private citizens includes corporations and businesses, of course, but private citizens can own and exploit asteroid resources recovered in space and brought back to Earth. That's Section 402 of the statute. And also that our federal courts have exclusive jurisdiction over any asteroid-related disputes. So it may be a contractual dispute, but if the subject matter is an asteroid, the federal courts have been deemed the place of exclusive jurisdiction for future asteroid fights. It's like that video game Asteroids from the 1980s. It's now going to be in federal court when there's wars. Now, this is an incredibly important piece of legislation in the space arena, and it really marks, as the private realm I've talked about has had an inflection point in terms of space exploration and commercialization efforts, so too has the legal world, and the world that we as lawyers inhabit. Now, this is the first piece of space property rights legislation ever enacted here in the United States. And it's sort of a major legal step forward to start creating legal regimes for private property ownership of these asteroid mined materials. Now, of course, some treaty questions remain. Arguably, this stuff, it remains unanswered internationally. Different space law scholars disagree over whether the United States law would be actually in violation of the treaty or not. It hasn't been litigated yet, but presumably once the materials start getting brought back, there may be some fascinating litigation brought in the United States federal courts over the legality of this law vis-a-vis the treaty. And this will, of course, require assessing whether the treaty's prohibition on governmental ownership of celestial bodies reaches down and precludes private ownership of asteroid minerals. Not asteroids per se, but minerals removed from asteroids. And of course, for certain nations, the interplay with the Moon Treaty that we talked about would be particularly sticky, because those that have ratified the Moon Treaty have a real problem. This just wouldn't be lawful within their legal regimes. That, of course, does not apply to the United States. But the sum total of this is that this is really the most massive step forward to create a legal regime giving certainty in property rights. And that, of course, legally is critical for the development of all new business in new areas. And the United States has been on the forefront fantastically in terms of creating legal structures to give certainty in property rights. And this then facilitates, of course, investment and development. So you may be transactional lawyers watching this, and your clients may either want to set up funds to invest in this, or they may even be businesses that are engaging in this type of behavior, or you may have clients who want to come and invest in it. And they can at least have some certainty to know that if the commercial enterprise ultimately is successful, United States federal law has protected that investment in the sense of the property rights belonging to the company that harvests them. Now, there are, as I noted, European space lawyers, at least among others, who do believe that this American law violates the Space Treaty. And in effect, at least some European space lawyers interpret this as an appropriation by the United States of the global space commons, so to speak. And they see this as the first sort of devious step by the United States to retreat from this expansive sharing open treaty into now the commercialization and ownership of space by the United States. And that's sort of a minority view in Europe, certainly, but it's certainly an existing view. It's probably not the right view either. The better analogy probably when one is looking at this law is that it is perfectly legal as a United States law and perfectly within the Space Treaty, because the analogy really is fishing in international waters, and our international treaties vis-a-vis the high seas have made international waters really open for fishing to all. And so the waters can't be owned by any nation. So in the middle of the Atlantic Ocean, it doesn't belong to anyone, and it cannot belong to any one nation. But any nation can fish there. And so the asteroid is sort of a comparable analogy. The asteroid is like an international water. It can't be owned but it can be mined and harvested for its resources. And so that probably is the better analogy, and it does seem correct that our United States Asteroid Act of 2015 is a lawful act. On the next slide, you can see this act was not one that was snuck through the Congress and signed by President Obama in the dead of night. This is one that had massive bipartisan support. I mean, it's sort of a fantastic testament to the fact that in this politically divisive world that we're in, this is one area where people from the Republican Party and people from the Democratic Party and people in the middle have all been in agreement in terms of embracing the idea that we should create these regimes to incent new development here. And so you can see here a quote from Senator Murray, a Democrat from Washington, after the passage of this legislation, the Asteroid Act, and he said, "I'm glad that we've taken this important step forward to update our federal policies to make sure they work for innovative businesses creating jobs in Washington state." Washington, footnote of course, is a state that has a heavy involvement obviously in the aerospace and space industry, and so for his state it was particularly important. And so as he noted, Washington state leads in so many ways, and I'm proud that the local businesses here are once again at the forefront of new industries that will continue to help our economy grow. And then you have a Congressman Posey, a Republican from Florida, who said, noting, "This bipartisan bicameral legislation is a landmark for American leadership in space exploration. Recognizing basic legal protections in space will help pave the way for exciting future commercial space endeavors. Asteroids and other objects in space are excellent potential sources of rare minerals and other resources that can be used to manufacture a wide range of products here on Earth and to support further space exploration missions. Americans willing to invest in space mining operations need legal certainty. They can keep the fruits of their labor, and this bill provides that certainty." So you see the underlying concerns that are echoed in these statements accompanying the passage of the legislation relating to obviously economic and aspirational scientific ideas, but basic economic ideas about the wanting to support business and help business grow, but also sort of basic legal principles about one should keep the fruits of their labor and those types of concerns that animate much of our legal regime. And so the net result here is that there's a clear path forward with a clear legal regime of clear certain property rights for U.S. companies in the United States to let them now begin these new asteroid mining operations. Now, as we turn to the next slide, you see this, as a result, has led to competition. So we may have been the first to create legal regimes to incent capital to move in and to incent businesses to join this fray so that we can get in on asteroid mining to get whatever's valuable off an asteroid. But as it turns out, we are now not alone. Recently, Luxembourg has passed similar legislation, and other countries clearly are talking about following. And so there will now be a race, a new space race involving asteroid mining, and this space race is going to be looking for standards that encourage capital to flow into such projects. So keep your eyes out because other countries are going to be in on it. Not a final issue, but one other issue to look at here is space debris and what do we do with space debris. Mentioned early on, this issue of dead astronauts and people who die and what you do so that you don't contaminate space and violate the space treaty. But there's also an issue about space debris. There are currently over 600,000 objects in the orbit of Earth currently. It's a stunning number of material circulating, around our Earth at any given time. And the liability regime currently is only for negligence. And so if enough material builds up, accidents are inevitable. We talked about the complex, massive factual questions about who would be responsible. But one of the key holes in the legal regime here is that we simply need legal advances to address what we could call floating junk, because there's a lot of now dead satellites and dead junk in space, but there's no legal salvage law that allows one state to simply get rid of someone else's junk and get rid of it because it's salvage or abandoned junk now. So these salvage laws that we have in our states to deal with terrestrial property, we now need to create space extraterrestrial salvage laws. And so if we look at our last hypo today, this one comes, we've covered Star Trek and The Martian, we now have to cover Star Wars. So this is Han Solo in Star Wars in the Empire Strikes Back movie, where he said if they follow standard imperial procedure, They'll dump their garbage before they go to light speed, then we just float away with the rest of the garbage. And you can watch this little video clip here.
Captain Solo, this time you have gone too far. No, I will not be quiet, Chewbacca. Why doesn't anyone listen to me?
Fleet's beginning to break up. Go back and stand by the manual release for the landing claw.
I really don't see how that is going to help. Surrender is a perfectly acceptable alternative in extreme circumstances. The Empire may be gracious enough.
Thank you.
What do you have in mind for your next move?
Well, if they follow standard Imperial procedure, they'll dump their garbage before they go to light speed, and then we just float away.
The rest of the garbage. Then what?
Then we gotta find a safe port somewhere around here. Here we go, Chewie. Stand by. Detach.
You have your moments. Not many of them, but you do have them.
All right, so you saw that fantastic clip from Star Wars, and the question we need to ask is, would this be legal under our law? And it's a very important practical question, because now that space travel and space exploration really is expanding rapidly, you're going to have a very practical question to address. It's the practical question that we've addressed here on Earth since the time of the ancients, and that is, what do we do with our trash that we collect? Trash will be created during a voyage or as a result of mining, efforts, the waste that's created. And the question is, bluntly, can companies dump their junk in space? So, if the Empire in Star Wars, if the Empire were regulated by our international treaty and our laws, the question would be answered as follows. What the Empire and Darth Vader did there, dumping their junk in space, would be a violation of the space treaty. It would violate the prohibitions against contaminating space. You wouldn't be able to just dump all that junk into space, contaminate space, and then also create the risk of it re-entering orbit and damaging a terrestrial set of beings for us here on Earth. Now, obviously that space treaty was premised on the idea that we may go to the moon, we may fly around the Earth and come back. It never was really envisioned in 1967, particularly, that there would be sort of genuine private space industry with mass travel and transit in space. And so the aspirational idea of the treaty to never discard junk into space, notwithstanding the staggering vastness of space, obviously, that aspirational idea is going to collide with the practical reality of space travel very, very quickly here. And so the next bodies of law that will need to be developed will be sort of following on the heels of asteroid laws. Will need to be legal regimes being developed to deal with the reality that trash is going to be created, can't all be stored, and may need to be disposed of in space in some manner. And so in a manner to avoid re-entry into an orbit of Earth too. So these new complicated legal questions are on the horizon, but at least for now, dumping junk, it's illegal. Our final topic now is the law and extraterrestrial life. And now we get to ET. And so the question we need to look at here is, if some extraterrestrial life form is found, who owns it? Who owns ET, so to speak? So, cell life. Imagine if, as asteroid mining companies or comet mining companies or moon mining companies or Mars mining companies or any celestial mining companies are going about their business mining the surface of some planet or some celestial body, and they discover cell life. The question will become, what happens to that cell life? Who owns it? And can it come back to Earth? The first answer under the space treaty is that could be a potential contaminant that is illegal to return to Earth. If you remember, Article 9 of the space treaty says that parties to the treaty shall pursue studies of outer space, including the moon, and conduct exploration of them so as, quote, to avoid their harmful contamination and also adverse changes in the environment of the Earth resulting from the introduction of extraterrestrial matter. So, we have an Article 9 treaty that at least provides that the potential, at least, that if cell life of some kind is found, returning it to Earth could arguably be a harmful contamination and therefore illegal, and or it could arguably create adverse changes in the environment of the Earth, which would also be a violation of the treaty. So it may be that it's illegal to return that cell life to Earth. Now the counter argument to that is that the cell life would really be matter within the asteroid miners law. And so it would simply be just like taking a piece of metal or platinum out of a mine. They found some cell life, and so it's private property that now belongs to the mining company. This, though, creates new complex questions, and this is where, at some point, the law of intellectual property, which is where I practice for my living in copyright law, the law of intellectual property will need to also be developed at some point to account for space-based developments, because if cell life of some kind is found, there may well be intellectual property or patent derivations for drug development, for example, that come from that. And under the asteroid mining law, the answer yielded for the legal analysis would be that that belongs entirely to the owner of the underlying asset that was found, i.e. the mining company, and any of its business partners, of course. But the space treaty also provides that scientific endeavors in space are for the benefit of all humanity. And that massively important aspirational principle that if we do have real scientific endeavors, they belong to everyone, collides with private property regimes if new drugs, for example, are precluded access to people because of patents and prices and money and all that. That's inconsistent with the idea that scientific endeavors are benefiting all humanity. So these are fascinating unanswered questions that now remain. And so you see on our conclusion slide, who knew? Space, the final frontier. Our major conclusions really are fascinating for this new world. And for 50 years, the government regulated this, and now we're in a new place where private enterprise is heavily involved. And lawyers, our generation, future generations of lawyers will more and more have to start dealing with space law issues because of these technological advancements. And the space law issues are fascinating, from property rights, as we saw in mining laws, to liability regimes, to allowing testing and safety protocols for commercial private space travelers, to limitation of liability regimes for suppliers. It's a massively and rapidly developing area of law that's evolving in real time quickly. It changes month to month, year to year. And ultimately, myriad unanswered questions remain, which make this a particularly interesting area of law with potentially conflicting legal answers. So it's fun, it's interesting. I hope you had an enjoyable, light, and pleasurable, whimsical walk through space law. If you have any questions, as always, feel free to email me, pafrasiabi@1lp.com. Thank you.